Hey, all right, everyone. Thanks for joining us on a Friday morning / early afternoon. I know some of you are probably eating lunch and getting ready for the last half of your day before a good weekend. And today we're going to be talking about estate planning for the people that you love. And it's often something that I repeat over and over again to potential clients or to anybody who will listen, really. Estate planning, as we're going to discuss today, is really about who you love and what you love, and less about what you have. There's a lot of people that call my office and they might say something like, well, I don't think I have enough money for an estate plan, or I don't have a large enough estate to, need to hire an estate planning attorney. And estate planning is really about who you love and what you love. And it's not about what you have. And we're going to talk about that in just a second. And so let me start the presentation here. All right. So my name is James Long. I am an estate planning attorney. I'm the owner and founder of an estate planning law firm in Ontario, California, and Costa Mesa, California, called Regan Legacy. We have other satellite offices, about 10 or 12 other locations throughout Southern California. The upshot is that wherever you are, I'm probably about a 10 or 15 minute drive from you. So, don't think that you got to come to Ontario or Costa Mesa just to meet with me. And we also do Zoom. But I always tell people I'm an estate planning attorney, I'm a lawyer, I'm a business owner, but really I'm a husband and I'm a father. And that really plays a lot into my estate planning journey and the way I think about estate planning, because the way I do estate planning and the way I think about estate planning now that I have kids, is completely different than the way I did it before. The legal documents are all the same, basically, but the way I think about it and the way I strategize with families is just completely different. I've been doing this for about 10 years. I'm a former expert for the Vatican at the United Nations, I started Regan Legacy. One of the things you should know about Regan Legacy is that we really focus on personal client touch. We focus on, I would say, giving particularly families with young kids the attention and the scrutiny that they deserve, because oftentimes it's families with young kids that neglect the estate planning, and it's the families with young children that can run into the most problems, the most legal problems after an unexpected death. So here's a little bit about my firm. We were named the most innovative estate planning law firm of 2020 by Acquisition International, and Lawyers of Distinction gave us an award for excellence in estate planning law. All right. Now, I've touched on this already. One of the biggest misconceptions about estate planning is that you need a lot of money to do it, to make it worthwhile. And that's just not true. And I'm going to prove it to you in the next slide. Here we go. Everyone in California, I don't care how rich you are, how poor you are, you already have an estate plan. The state of California has made an estate plan for you, for your family. That estate plan is called Intestate Succession. It's a series of laws in the probate code that go over what happens to your property when you die, who it goes to, and who it doesn't go to, and when that property transfer takes place. And so if you're the type of person who is fine with the state of California directing and controlling your assets when you die, and deciding how and when and to whom your property gets distributed, then stick with the state's plan. You don't need an estate plan because the state has already done it for you. But the state's plan is very expensive, because although it costs you nothing up front, on your death, your kids are going to have to pay, at least in Southern California, an average of about $22,000 after you die. And so really the calculus for a lot of parents is, do you want to spend a few $1,000s working with an experienced estate plan now, or do you want to force your children to spend $22,000 to $30,000 later going through the state's plan? And that's just a calculus you have to make. spend $30,000 later, spend a few $1,000s now. And that's really what it comes down to. All right. Now, I touched on this again earlier, that estate planning is less about what you have and it's more about who you love, because your estate, right? The law only cares about your property, right? Your house and your cars and your bank accounts. But what you care about and what's truly unique about your legacy and what's truly unique about your estate is your family. It's your loved ones. It's the people in your life that you love. And the law, frankly, doesn't really care about any of those people. The law is not set up to care about any of them. The law, in fact, the state's plan, right? If you decide not to have an estate plan at all, the state's plan's goal is to pay your creditors. The state's plan is to set up an estate plan for your creditors and not really for your loved ones. And that's why it can get very expensive. That's why it takes so long. After a parent dies, I get 4 or 5 calls a week from children whose parents have just died. Their dad, their mom died without a will. Maybe they died with a will, and they've got to go through the probate process. They're scared. They're confused. They don't know what to do. And I've got to sit down and tell them, I know there's a lot of bills to pay, but you're not going to have access to any of that money for 2 years, because the whole court system has to go through this process called probate. When you have the state's plan or when you just have a will, you go through this probate process. And the state's plan really is not about who you love. It's there to protect your creditors, and not really your children or your spouse or your loved ones or your church or whatever else. All right. So the way we try to do estate planning at my firm, and the way I think about estate planning, is to have an estate plan that's drafted so it operates in the background of your life, that it's this sort of companion that travels with you. You don't even know it's there, but when you need it the most, it steps in. It's effective. For example, aside from getting calls from people whose loved ones have died with a will or without a will, and they have to go through probate, the second most frequent call I get in my office is a conservatorship. A conservatorship because a loved one is sick, they can't take care of themselves anymore, they can't pay their own bills, they're falling into undue influence. Well, an estate plan has a plan for that, right? Advanced planning is able to prevent those kinds of things through, for example, healthcare directives and powers of attorney. When you execute a healthcare directive and power of attorney, most often you're nominating a conservator. And most often, what you can do is avoid having to go through a very expensive and time-consuming conservatorship process, because you've already nominated somebody who can step in and take care of you, either take care of your health or take care of your finances after you've gone. And so what a really good estate plan does is it helps protect your loved ones when you can't do it, right? Either because you're sick, because you've died, because you no longer have the capacity or capabilities to do it. That estate plan then comes in and allows and directs your loved ones as to what to do and gives them the power to do the things that they need to do, like pay bills, like make medical choices, and things like that. So that's what we try to do with our estate plans at Regan Legacy, and that's what we really focus on with our estate planning. Okay. Now, we're going to break this presentation up into the different types of people that you love, because that's how I like to think about estate planning. And so one of the first people we're going to talk about is your spouse, right? If you're married and you're listening to this, you've got a spouse, and that's probably the first person you're going to think about, when you're thinking about what would happen if I die. I know that's true of me as a husband. I'm immediately thinking, if I were to die, what would happen to Vanessa? And then the second question for me is, what would happen to our kids? And so let's tackle that first question first. What would happen to your spouse? And here's the questions you need to kind of think about and answer for yourself, because those the answers to those questions are going to guide you into what kind of estate plan you need, whether you need a complex plan or maybe a more simple plan, because again, we've talked before, estate planning is not necessarily about what you have. It's about who you love and what you want to happen and what kind of protections you want for those loved ones. So first question you need to ask if you've got a spouse: what kind of life do you want he or she to have after you die? What do I mean by that? If you've engaged in a lot of financial planning, maybe you have life insurance, maybe you have a good retirement that's going to help your surviving spouse, help provide an income for your surviving spouse, and all that's great. What I'm talking about here is, how easy do you want, or how flexible do you want your estate plan to be on your death? So, for me, I need to think about, how easy do I want it to be for Vanessa when I die? Do I want it to be complicated, or do I want it to be simple? All right. Because as you're going to see in a second, there's a dichotomy. There's a tension between, I want it to be super simple and easy for the survivor, but I also want it to be protective, because the more protective a trust is, the less simple and easy it is. So you kind of have to balance the kind of life you want your survivor to have. All right. The second thing that goes into that kind of conception of what kind of life you want them to have is, what's the reality of the estate? Okay. And that's going to vary from person to person. Some people have very large estates, and it's going to be hard for a spouse to manage, right? If you're part of a couple who, maybe you don't pay the bills, or maybe you do pay the bills, but your spouse doesn't pay the bills, is it going to be difficult for that spouse to step in and manage, say, rental properties, or manage investment, an investment portfolio? And so you need to think about, what kind of life do you want them to have? Is it going to be something that's going to be a turnkey thing, or are they going to have a little kind of catching up to do? Because there's ways you can design your estate plan to kind of make it easier on your spouse. Okay, the second question. All right, is it likely that your spouse is going to remarry after you die? Now, when I see, we see a lot of young families in my office, and so this is sort of a heart-to-heart conversation I have with my young family kind of couples. And it's prevalent with young families, but just because you might maybe be over 50, over 60, into the 70s, it doesn't mean you're immune from this either. But mostly with young couples, if a spouse dies young, if I were to die today, I would assume my wife is going to get married. She's absolutely gorgeous. She's a bombshell. I married up. She's practically a model. And although her sister's the model, but anyway, she comes from a family of models apparently. But she's probably going to remarry. And so when I'm going through the estate planning process, I need to be aware that, hey, if I were to die at, in the next couple of years, it's likely she's going to remarry. And how's that going to impact the estate that I leave behind? And am I okay with that? Do I want to build protections in place just in case she does remarry? And then if you're, in the retirement years, you're not immune from getting remarried either. I've got calls, not all the time, but I get calls maybe once or twice a month from, it's usually an older gentleman, and he starts, he finds a girlfriend, right? Maybe his nurse or caretaker, and they develop a relationship. And the kids call me thinking, what's happened? My dad's like giving all this money to this person. What's going on? And, if the estate plan was set up properly to begin with, the kids will be protected. But if it wasn't, if that thought didn't go into it when it was being designed, your kids could have a problem. All right. And then if you have children, another thing you need to think about is, again, in a remarriage situation, are you worried about a potential stepfather, stepmother type of situation? Because estate planning for a blended family is different. There are just different considerations you have when you've got a blended family. By that, I mean, you've got, where the parents of the children are not maybe the birth parents, right? Or the natural parents. You might have a stepmom or a stepdad, or you might have, children from prior marriages and things like that. Well, in my own case, if I were to die and my wife remarries, well, that new husband is going to be my kid's stepdad. And so what kind of steps can I take in my estate plan to protect my children from the stepdad? Because we all have heard horror stories, and I get phone calls in my office from people who, their parents remarried. The estate plan was not protective enough. It basically gave the surviving spouse complete authority and control. It was very easy, but it gave them complete authority and control. And their kids' inheritance ultimately went to the stepdad or stepmom. And I'll tell you a quick story about a call I received just a few weeks ago. The dad of this particular person had bought a house with his girlfriend. Mom and dad got divorced. Dad started dating somebody else, but they bought a house together. And what ended up happening was dad and the girlfriend broke up. But dad never created an estate plan, never saw an estate planning attorney. And I know what would happen in my office, and it's one of the very first things I do. Someone comes in, I tell my client services director, pull the deed to the house. I need to see who's on title and how they're holding it. Because what happened was, even though he broke up with the girlfriend was still on title, and they were on title as joint tenants. So when the dad died, the mom or the girlfriend, the ex-girlfriend, now has the entire house. His kids got nothing because he didn't see an attorney before he died. And so when you're thinking about estate planning, and you're thinking about a remarriage situation, and you're thinking about what would happen, these are the types of questions you need to answer, because this is going to protect your spouse, and it's going to protect your kids as well. All right. So depending on how you answer those questions, that's going to decide what kind of estate plan you might need. If you want it very flexible, if you want it very easy, kind of easy on the spouse to give the spouse maximum authority, you want what is normally called a disclaimer trust. It's a disclaimer trust. It means that everything goes to the spouse, and then on the first spouse's death, everything goes to the spouse, and then that spouse can disclaim anything that he or she doesn't want. If you're worried about a remarriage, you want something that's called, typically an A-B trust. The A trust is the survivor's trust. The B trust is the decedent's trust. And basically on the death of the first spouse, it splits into two trusts, and half the trust is protected so that if there is a remarriage, at least the kids will be protected in half of the estate, their dad's estate or their mom's estate. And then the other half is free to go wherever it wants. And the survivor can dispose of it however they want that way. Okay. All right. Next, we talked about spouses. Now we're getting into kids, because when we have kids, it's we've got work going on over. I don't know if you hear that, but there's a ticking going on. Someone's doing work on the wall. So if you hear that, I apologize. When we have kids, there's a whole host of other concerns and other things you want to think about. Okay. And I know this now that I'm a dad, especially a dad with young kids, than I did before. When it comes to our kids, we do everything we can to protect them. Everything. I mean, we obsess over bike helmets. We look at safety ratings on toys. And, I brought something home one time when we first found out that we were pregnant with our first son. And there was a fire safety warning on one of these things. My wife had read in a blog that it was not good for fire safety reasons, and we had to get rid of it. Because when it comes to our kids, we are so particular about what happens, and we're very meticulous about keeping them safe. We want to protect them from potential dangers. Well, your estate plan can and should. It should be designed to be a device that protects your children at all times. It amazes me when parents spend so much time protecting them from drugs, and you want to protect them from injury, and you make sure they wear their seatbelts, and you do all sorts of things and buy the best of the best to protect the kids, to make sure they've got a bright future. And then when it comes to your estate plan, you just neglect it. And what happens is they call my office. They're scared. They don't know what to do. They don't know where the bills are. They don't know where the estate is. And now they're involved in this 2-year probate process. And at the end of it, they get a bill for $20,000, $30,000, $40,000. And they look at me like, how am I supposed to pay it? And sadly, the only real thing that they can do is they've got to sell the family home, or they've got to sell mom's wedding ring, or whatever it might be, to just pay the probate bill. I mean, it boggles my mind, because just for a little bit, a fraction of the cost, you could provide so much protection for your kids. And let me show you how. Let me just show you how. Okay. All right. So when you die, especially if you have minor children, we'll get to minor children in a second, but regardless of whether your kids are old or they're young, when you die, your kids are going to be faced with a series of threats. They're going to be faced with a potential probate bill. They're going to be faced with predators who want to prey on them because they know they're inheriting money. There are people who sit at the probate courts and they watch and they look and they see who the vulnerable person is that's receiving an inheritance, and they go and they prey on them. It happens all the time. You know, friends come out of the woodwork. They know you just inherited money and they come up with a business investment, right? I get calls all the time about that, you know, where, you know, so-and-so lost their inheritance on a business investment, or they gave the money to a friend to invest in such and such, and the friend ran off with it. That kind of stuff happens, and you need to be able to protect your kids from it. Okay, so examples and solutions. All right, the biggest threat you're going to have with your kids is honestly substance abuse, bad choices, their own bad choices, creditors, divorce, and judgments. Okay, now, your kids, and only you know your kids, right? And if you got young kids like mine, I don't know whether my kids are going to be prone to substance abuse. I hope not, but I just don't know because they're so young. All right, but you will know your kids. All right, you'll know if they're prone to substance abuse. You'll know if they're able to manage finances, right? If they're not able to manage finances, they're going to make bad choices. They will fall prey to undue influence. They're going to be the type that will invest in their friend's business and lose it all. They might have really bad financial management skills, and they might be severely in debt, going through a bankruptcy, something like that. They might have a bad relationship with a spouse and might be going through a divorce, and a divorcing spouse might take the inheritance. They might maybe have engaged in some sort of civil or maybe even criminal conduct that's resulted in a civil judgment, and they've got to pay a fine. There are ways you can protect your children and your estate from these kinds of things. How do we do it? Well, here's one of the biggest mistakes people make, and this is the easiest thing you can do to protect your kids from that kind of stuff. The biggest mistake people make, and I've got clients who I tell them the risks and they still say, no, give it outright. And that's fine. If that's your wish, that's fine. But you have to know it is one of the biggest mistakes. It doesn't mean that your plan's going to fail, but it does mean that if it fails, this is often the reason why. Okay. Biggest mistake number one is you allow your children to get the inheritance outright. This is what that means. If you have a will, if you don't have a will, or even if you have a trust and it's not properly drafted, your kids, when they turn 18, or if they're already over 18, as soon as everything's ready to be dispersed, they're going to get a check or whatever the inheritance is outright. There's no strings attached. There's no conditions placed on it. They just get it. Now, if you think back, and if you've got young kids, and this is why I really like representing families with young kids, because you can really help prevent some of these bad things from happening. But if you think back to when you're 18, 19, 20, 21 years old, and what would you have done if you would have gotten a check, let's say for $100,000, $200,000? You just, all of a sudden, you got your inheritance and there's no instruction. It's just sort of, have fun, kid, you got the money. Now, when I was 18, I would have blown that money. When I was 20, 21, I'd like to think I was a little more responsible, but let's be honest, I still probably would have blown the money. I wasn't able to handle that. And I suspect maybe your kids are the same. Now, if you have older kids, it might be less of a concern, but there's still some other reasons why you might not want to give a gift outright. And we'll get to that in a second. But if you've got kids who are under 18, you really don't want to be giving their inheritance outright, because there are countless examples where a teenager will get an inheritance outright, and all of a sudden they've got tons of money. They go spend it on partying, drugs, get addicted, and within a year they're either in jail, they're homeless, or whatever else, because they used their inheritance and shot it up their arm, snorted it up their nose, or otherwise gave it away to friends or unscrupulous sort of people who come out of the woodwork with business ideas. And the scary thing is, as a parent, the scary thing for me is that you don't really know. You don't really know what kind of influences are going to be kind of acting on your kid's life. While you're gone, you don't even know while you're alive. Your kids go to school, and you don't know what kind of influences they're coming that are operating on them, and you don't know the degree to which those influences are going to impact them. That those influences are going to convince them to do something that maybe your family morals say they ought not to do. So because we don't know, we can do three important things in our estate plans to make sure that our kids are protected, and that the estate is protected. And here's what we can do. Here's the three things. First, and this is the most simple, all right? You could stagger the ages at which your kids get the inheritance. So if you've got kids under 18, you could say, they don't get their inheritance till they're 25. And then you could stagger it by years. You can say they get it all at 25, or you can say they get 30% at 25, the other 30% at age 30, and then they get the rest at age 35. Or you can do it, however you want. There's no law requiring what age it is or what percentage it is. The trust law is purposely very flexible to allow you, the parent, to decide how and when that gets dispersed. The second thing, and this is particularly, I think, the most effective for remaining with your child throughout his or her life. You can condition the inheritance. So you can, on the one hand, you can say they get it at 25. On the other hand, you can say, well, they don't get it until they graduate college. Or you can say they get $50,000 to use for college, and then when they graduate, they get another $50,000. You can use it, to say, hey, this is going to be reserved for their wedding. One of the most effective estate plans that I've seen a client do, that I've helped a client with, and it's something I've incorporated in my own estate plan, and it's the following. We had a dad and a mom. They had young kids, and they did conditions. And what they did was, they planned so that their estate was with their kids at all the major events of their life. Because the exercise you go through as a parent, and when you do estate planning with us, we put you through this exercise, which is, if you died today, what would you want to happen? Where are your kids, and how does the rest of their life look? And for them, I asked them the question, what would you miss the most? Like, if you died today, what would you miss the most as your kids growing up? And, the mom said, I would miss them at graduation. I said, great. Well, here's what we'll do. We'll put a provision in there that on their high school graduation, they get money to buy a car, right? And so that trust is there for them. So at graduation, mom and dad get to buy them a car. And then the dad said, I'd really miss getting to buy my son his first drink. So we took $20 of that trust, and we said, this $20 is reserved in the trust. And on the 21st birthday of the son, the trustee is going to go to a bar and take that son to a bar and say, this $20 is from your dad. And your dad wanted to buy you your first drink on your 21st birthday. And, I'm getting a little teary-eyed because I think about that with my kids. And if I died now, those are the things I would miss. But my estate plan can be there. It can be there every step of the way so that I can buy my son his first drink. I can get him a car when he graduates high school. I can, we don't have a daughter yet, but if I had a daughter, I can reserve a chunk of money so that I can pay for her wedding dress. We can have an estate plan that is kind of following your kids through these big moments in life, and mom and dad can be there just like they always have, albeit through a trust and not necessarily in physical form. But, I'm a Catholic law firm, so I would believe that, you're there in spirit and the trust is there in physical, but, you're free to believe something different. Okay, so here's the third thing. You can create a spendthrift trust. What does that mean? You might hear this as like an asset protection trust. You might hear this as a spendthrift trust, as I said. You might hear this as a protection trust. Sometimes it's called maybe a dynasty trust. It depends how it's set up. But what you can do, and depending on how complex or how simple you want it to make it, is you can say, okay, I'm going to appoint an independent trustee. What does that mean? I'm going to name someone who's not my kids to be the trustee to manage the funds after I die. And the trustee is going to be instructed that if my kids are addicted to drugs, if they're going through a divorce, if they are going through a bankruptcy, if they're just not really good making financial decisions, if they haven't graduated college or whatever conditions you put in there, that the trustee gives them no money. They're essentially cut off from the trust. And what that does is that if they have a divorcing spouse, right, the divorcing spouse can't come in and say, I want half of your inheritance. Because as soon as the divorcing spouse says, I want half your inheritance, the trustee, who's independent, then says, no, you're not allowed to get it because I decide when they get it, and I've decided not to give it to them. And there's nothing that she can do. Well, practically nothing. There's always savvy things attorneys can do. And maybe we'll have a webinar on my sort of cynical view of the law. My wife frequently asks me, can they sue for that? And I always tell her, anybody can sue anybody. And so, yeah, the ex-wife can probably sue. And yeah, she might get some money, but legally she shouldn't. And you can set it up so that there are protections in place. Okay. So that's the third thing you can do when you've got kids. You've got the first, stagger everything at certain ages and certain percentages. Second, make conditions. And those are very simple. My firm, we don't even charge extra for those kinds of provisions. Now, if you want a more complicated, like a spendthrift kind of thing, that does come at a premium, and usually most firms would charge for that. Importantly, that's not something you can get through LegalZoom. If you're subscribed, this will be posted on YouTube, and if you're watching this through YouTube, keep an eye out because we're doing a YouTube series on all the like LegalZooms and Rocket Lawyers and NOLOs of the world, and the spoiler alert, none of them are really set up to do any of the stuff we're talking about, at least not do it well. That's the topic for another presentation. All right. So we talked about kids. Now we're going to get even more specific about minor children. If you got kids under 18, that's where I exist. And frankly, because I have kids under 18, I started thinking differently when I said I was like, having kids changed my life as an estate planner. It's really this portion about minor children. And the way I think about estate planning is just completely different. So minor children, if you got minor children at home, there's some other things you need to worry about apart from where your money goes and when it goes. All right. So story time. All right. This is a true story. When my oldest, his name's JT, when JT was about 2 years old, Vanessa and I, we were going to have a date night. And typically we leave our kids with the grandparents, my wife's mother and father. They live real close by. My kids love them. They're responsible. They know what to do. We just leave them. But, we wanted to give grandma and grandpa a break and the rest of her family. So we decided to hire, one of the neighbors. She's a great girl. She's 16 years old, super responsible. Like she babysits for a lot of friends of ours. So she has got a lot of experience. She's really good with the kids. So we left her with her. And that's something that my parents left me with babysitters. Parents leave kids with babysitters all the time. And that's not a legal worry. That's not an issue. But here's what happened. I'm an estate planner. So during this date, I started thinking about what would happen if Vanessa and I didn't make it home. we got in a car accident. A truck fell over and crushed us. Who knows? Whatever might happen. My realization was that if something had happened to Vanessa and I on that date night, my kids, JT and Nolan, would be taken to the custody of Child Protective Services. Why? Because when the police, they would open our wallet, they'd go through it, they'd find our address, they'd go to our address to notify the family, and they would find my 2-year-old, and at that time 1-year-old, and a 16-year-old unrelated non-family member girl. And that person didn't have any instructions. That person had no clue who to call. And so the police would have no choice but to take my kids into protective custody until they could locate an adult suitable to take the kids. And that just didn't sit well with me. That to me was just unacceptable, that my kids would learn about, they would learn that mommy and daddy aren't coming home sitting at the home of a stranger or in the back of a police car. That's just not acceptable to me. And I don't think it's acceptable to most parents. And so I started thinking, how can we protect against that? How can we build our estate plans to make sure that those kinds of things don't happen? All right. So here's what I came up with, and here's what we do at Regan Legacy. We have something called, it's a kids protection plan, and it helps, it basically helps protect your kids from that exact type of scenario. First, we always have our parents nominate a long-term guardian for kids. That's pretty standard. Every estate planner outside there, right, just outside my window, I could see the offices of 4 or 5 other estate planners. They're going to do the exact same thing. They'll give you a long-term care guardian for your children. Mostly it'll be probably in the will. There's a problem with that. If they nominate the guardian in a will, that will has to be probated. So the guardian can't be effective until you admit the will to probate. And that's a long, sort of convoluted process. But they would do it. But here's another thing. We also nominate a short-term guardian. And the difference is this. The long-term guardian is who you want to be the guardian of your children if you can't do it. And who's going to be the guardian for the long haul, right? Who's basically going to be mom and dad for the kids for the rest of their, young life until they're 18. A short-term guardian, on the other hand, is someone that a babysitter or the police can call immediately. And within 20 or 30 minutes, they can get to the house so that the kids never have to go to Child Protective Services or otherwise have to go, somewhere that they're not with family, okay? The second thing, you need to have an emergency card in your wallet that does a couple of things. It needs to identify you as a parent with a minor child, because when you get into an accident, especially a car accident, the EMTs, the paramedics, they're trained to go through your wallet to see, one, who you are, and also if you have any religious beliefs or instructions about healthcare. And so when you have this kind of card in your wallet, it will identify you as a parent with a minor child, and that heightens, right, the level of sort of urgency that they're going to call the next of kin with. They're either going to, they know that there's a minor child, that those minor children are depending on you who have just been in an accident, and they're going to act a little bit quicker. But number 2, it needs to also say who to contact. What family members can they contact in the event of emergency so that they can call up your short-term guardian and say, hey, there's been an emergency, go get the kids. We'll brief you later, okay? The third thing, if you use babysitters, you need to have emergency instructions for the babysitters, identifying the people he or she needs to call in the event of an emergency, just in case the police knock on the door and try to notify the next of kin so that the kids are protected. And the final thing that we like to do is give instructions to your long-term guardians regarding how you would like your children to be raised and the immediate steps they need to take to step in. Because a lot of times you might nominate a guardian and maybe you don't tell the rest of the family. It's a secret, or maybe you just didn't get around to it. And what happens is the family comes out of the woodwork and they start fighting over who's going to get the kids. What's going to happen? And the number one reason why families fight over who gets the kids is so-and-so alleges that this person is not going to raise them with the values that the parents had, right? And so they go to the court and they object. And the court really doesn't care about your values. The court cares about, is the person in a stable relationship? Are they financially secure? Is it going to be a stable environment? And what's going to be the least sort of traumatic change for the children? So, the court's not really going to take your values into account. But if you've left instructions for your guardians and you say, hey, I want our kids raised Catholic. I want our kids raised fill in the blank. I want our kids raised to believe X or whatever it might be. There's some legal recourse or at least some proof that, some family member saying this person doesn't agree with X, Y, or Z, or they're improper to raise the kids because of some value. There's some proof for the court to either prove that or disprove it. And so it really kind of prevents those kinds of disputes from occurring. Which ultimately protects your children, because the last place you want your kids to be after you die is in court where the family is just fighting over who gets to take care of them. All right. So we talk about minor kids. Let's talk about fur kids, fur babies. Some people have non-human babies. They call them fur babies, puppies, animals, whatever you might want to call them. I call them fur babies. Whether human or not, you might have a pet child. You might have a dog, you might have a cat, a parakeet, whatever it might be. Now, the law has a succession plan. I mentioned that everybody has an estate plan. It's called Intestate Succession. The law has a plan for your natural human children, but they don't have a plan for your fur babies. The law doesn't care what happens to your pets after you pass. And so if you care about what happens to your pets after you pass, you need to engage in estate planning. And one way to do that is to set up what's called a pet trust. Now, we've read, I think even recently there was a story just a few weeks ago of a Texas billionaire, I think, who left $5 million to his dog or something in a trust, right? So we see all these kinds of things about pet trusts and things like that. Well, if you think about it, it kind of makes sense, because after you die, if there's no one to take the animal, if there's no one to care for the animal, that animal's going to be put down. They'll be taken to the pound or maybe try to be put up for adoption, but at some point they'll be put down, they'll put to sleep, and your pet will meet you in heaven. But if you set up a pet trust, or it doesn't have to be necessarily a separate pet trust, it can be, but it can be in your current trust, and you tell the trustee, hey, this chunk of money is reserved for the care of my dog, my cat, my fish, whatever. Then the trustee can then either take the animal, him or herself, or the animal can go to whoever you say it should go to, maybe a family or relative. But there's money set aside so that it's more likely that your pets get taken care of after you die, because there's an incentive, right? It's going to be easy to take care of them. They've got some sort of money to pay for their food and their treatment and all sorts of things, because that's the number one reason why people don't take a loved one's pets after you pass on. It's not because they don't want the animal. Maybe it's because they just don't have the finances to take care of it. And so one of the ways to protect your fur babies is to create a pet trust, or to make a provision in your trust to care for them. All right. So how do we sum up? There's all sorts of people, human and non-human, that we love, right? We love our spouses and our kids and our pets. And we didn't talk about like other family members, brothers and sisters, and we love our churches and we love our charities and we love so much in our life. And that's what estate planning is about. It's about who you love and what you love, because ultimately when you pass, your kids aren't fighting about the money. Sometimes they do, but really what they're fighting about is your memory, right? They're fighting about the memory of you and the love of you and the recollection of the love you share together. And so estate planning, good estate planning, is designed for everything you love in your life. And you need to work with an estate planner who understands that, who gets that there are things in your life that you love that you want to protect. And usually it's the spouse, it's the kids, it's the pets. And then after that, it could be brothers, sisters, nieces, nephews, churches, whatever else. But usually those are the major things we have in our life that we love. And there's ways to protect them, because the alternative If you don't do an estate plan, the state already has one for you, and the state's plan might not be what you want. Additionally, the state's plan, and even if you have a will, right? If you have a will or you go with the state's plan, it's going to be the most expensive plan you could possibly have. If you just have a will or you don't have a will at all and you go with the state's plan, your kids are going to pay on average of $20,000 to $30,000 to get it probated. And so the calculus is, do we want to have a trust that avoids all that? And you spend a few $1,000s, you get something that protects your kids, that actually walks with your family and plans for your loved ones. Or do you want to go the cheap route and force your kids to be involved in a confusing, long, and sort of prolonged process called probate that's going to cost them a lot of money, and that's going to pretty much force them, all but guarantee, that they have to sell their inheritance in order just to pay the fees? That's what you need to think about as a parent. All right, so what can we do? Here's our contact information. You can contact us. There's our phone number there. We also have a Costa Mesa number. It's a 949 number if you want a more local number, if you're in Orange County. You can email Rachel. That's her email. She's my intake coordinator. She'll get you set up with whatever it might be. If you're doing estate planning, we do a family legacy meeting. It's a 1 to 2 hour meeting that really is there to help guide you, right? Attorneys are both attorneys and counselors at law. This is the counselor at law part. Prior to the meeting, you'd send all of your family information to me. And then during the meeting, we'll go over it and I'll ask you the questions. What would happen to your kids if you didn't make it home? What would you miss the most? And as we start to uncover some of those answers, the answers to the questions we've asked in this webinar, I'll be able to make suggestions about, this is the type of thing you need. Here's about how much it will cost. And you can make the choice at that point to go forward or not. And if you want to go forward, you can pay all at once. You could set up a payment plan. You can finance it. There's all sorts of things that you can do, because at Regnum Legacy, we are really more concerned about protecting your loved ones and less concerned about, the fee, right? There is a fee there, but we want to make it as affordable as possible is what I'm trying to say. Okay. So, again, this is going to be posted on YouTube. And so if you want to follow us on YouTube, go ahead and do that. We have tons of other videos we're going to be posting. We have a nice Facebook, and Rachel does a great job with our Instagram page. So follow us on those platforms as well. And so final note is thank you. And I'm going to open it up for questions here. I'm going to stop the presentation and I'll open it up for questions. If there's any questions, go ahead and put them in the chat. All right, I've got a question here. And the chat is set up so it can be a private question or it can be a public question. And I've got a private question here, so I won't use names. If it's private, I won't use names or specifics. All right, so the question is, if I have parents that don't have an estate plan, my siblings and I will most likely need to pay $30,000 later. The answer to that is yes. If your parents don't have an estate plan, your siblings, I don't know how many siblings you have, but your siblings will have to pay approximately $20,000 to $30,000 at some later date, assuming they own a home. If they don't own a home, the fees will be much less, but once you own a home in California, the fees get sort of astronomical. The second part of the question is, what if my parents say they don't have so much money and they don't feel like they need an estate plan? Well, here's what you can do. Your parents might be right, okay? They might not need an estate plan. And here's how to tell. If your parents have less than $166,000 of total assets, so if you looked at their home, their cars, their bank accounts, their life insurance, not their life insurance, life insurance isn't counted, their retirements, their personal effects in their homes and things like that. And if you total all of that and the gross value, not the net, right? I don't care if you bought the house for $500 and you still own $500,000, it's $500,000 for this particular calculation. If the gross value is over $166,000, then yes, they need an estate plan. If it's less than $166,000, they might be able to get away with a small estate affidavit. But if they want to decide how and when their estate gets divided, even if they have less than 166,000, and they want to decide who gets that money, they need to have some sort of planning in place. And if it's a really small estate, like under 166,000, they could probably get away with a will. But even if they have a will, if they want to direct, how and when that money gets dispersed, and set up maybe an asset protection trust for their kids, or they've got a child with substance abuse, they really need to do that with a trust, because that's the only vehicle that will allow them to do that. All right. Here's another question. Do you do special needs plans? Yes. So one of the things I didn't touch on, when you're looking at your children and you're planning for those that you love, you might have a child or a brother or sister that has special needs. And if that's true, you can set up what's called a special needs trust. And a special needs trust is a special type of trust which will allow that person who has special needs to be able to inherit or otherwise own property that they otherwise couldn't, right? In order to qualify for government benefits, typically you need to have less than $2,000 in assets. So if you have an inheritance or you want to give someone with special needs money, it needs to be done through a special needs trust. And that trust is set up to pay for all the things that the government doesn't. So if they're in a protected facility, or if they get some sort of disability benefit or something like that, your special needs trust can be set up so that it keeps them qualified for all those benefits, but can then also pay for things like if they wanted to buy Christmas gifts for people, if they wanted, to go out to eat and buy food. I had a client who set up a special needs trust for her nephew. And the special needs trust, it wasn't very large, right? It didn't have that many assets in it, probably $100,000 or so. But that $100,000 was invested in an account, and the interest was used. And what it was used for was to purchase an annual bus pass, or maybe it was a monthly bus pass. And this particular person, he had high functioning autism. And so his routine, his daily routine that he had was he would take the bus and he would go to a part-time job. So that special needs trust bought him that bus pass so he can get on the bus. And he'd go to a job, and I think he worked just a few hours, maybe 2 or 3 hours. And then he would get on another bus and he would go to a series of I think it was like a McDonald's, then a Starbucks, then a Target, and then home. And that was his daily routine. And he would go to McDonald's, and the trust would have, a card that would be purchased every month for him. And he would buy his typical meal, hamburger or French fries or whatever it was. Then he'd go to Starbucks and he'd have his order from Starbucks. And the trust was purchasing that for him every month so that he could have this routine built up. So it doesn't have to be this elaborate kind of trust fund, but it can, it could be something very simple, like what my client had done from a few years ago. The point is that a special needs trust is a powerful tool if you've got someone who's on disability or who otherwise qualifies for disability benefits because they've got some sort of special need. It might be autism or Down syndrome or some other kind of disability, usually like a congenital type of disability, but it could be like a workplace injury. It could be all sorts of other things that would qualify somebody for maybe government benefits where a special needs trust would be used. It's also called a supplemental needs trust as well. So if you see supplemental needs or special needs, it's the same kind of thing. They're just called different things. So yeah, we do those plans. And if you're interested in any of that, you can reach out to us, give us a call. And I'm going to put in the comments, because I realized that's our phone number, because I took the graphic down, 951-228-9979. Go ahead and give us a call. And here's my email, jlong@regnumlegacy.com. Now, if there's a question that maybe you think of after this webinar and you want to email it to me, go ahead and email me that question. I'd be happy to answer it. You can give us a call, and Rachel will set you up. We can talk for a free consultation to talk about your issue. For example, if you think you might need a special needs plan, or you might need an asset protection trust or something, you can give me a call. We'll run over the facts and we'll tell you, yeah, I think this would be a good idea, or no, here's another alternative that might be cheaper, or maybe an alternative that's more expensive but more protective. And we can run down those kinds of options. So if there's no other questions, let me see. We'll give you like a going once, going twice kind of thing. Going once, twice. No other questions. With that, I want to thank you guys for attending this webinar today. This is something I'm really passionate about. I just, like I said, ever since having kids, planning for people that you love, especially estate planning for people that you love, is a passion of mine, because I've experienced firsthand as a parent the protections that an estate plan can offer, and all the fun things you could do to be there for your kids at these great moments in life. And it's just fabulous what you can do. And judging by the 4 or 5 phone calls I get per week from families who had no plan, it's sad that more people don't take advantage of it. So I hope you do take advantage of it. If you got any questions, email me, shoot us a call, shoot us an email, give us a call. But otherwise, thanks so much for attending, and we'll see you next time.